Welcome to our update on legal developments in parental rights in public schools. I'm Erin Craner, and I'll briefly introduce our two panelists today. Shannon Minter, one of the most senior attorneys in the LGBT rights movement, a former commissioner at the national level in a couple of appointments, and also a co-editor and an author. And I invite you to read more about him in his bio. And Jean Scher, an experienced appellate counsel and an adjunct professor here at BYU Law School. We'll hear from each of them. We'll have a question and answer period and also a discussion about the peacemaking aspect of parental rights in public schools. Jean?
Thank you. I'm delighted at the opportunity to engage in this important discussion with two longtime friends, Shannon Mintner and Erin. Shannon and I actually have been on opposite sides of some pretty consequential legal battles over the years. And very often when I get hired by a client who wants to take a relatively conservative position on a social issue, my first question is, I wonder if Shannon's going to show up on the other side. and I always enjoy it when he does. So on the subject of parental rights, I'd like to begin 100 years ago with a law passed by the Oregon legislature in what was likely a good faith effort to create a more homogeneous American culture. That legislature mandated that children attend public schools until they either reach the age of 16 or they complete the 8th grade. And as you can imagine, this was of some concern to the local Catholic schools in Oregon. And to parents who had elected to send their kids to Catholic schools and to other private schools, because now they were no longer going to be able to satisfy the education requirements by sending their kids to private schools. They were going to have to send them to public schools. And of course, they all thought their local religious schools or other private schools were doing a perfectly fine job of providing an appropriate education for their kids and doing that in a way that was consistent with the parents' faith commitments. But the state thought it knew best what was in the best interest of the state's children, and so it was willing to override the parents' judgment on that very important educational question. And so, supported by the parents, the Catholic schools in Oregon launched a lawsuit that would culminate in a decision of the U.S. Supreme Court that was decided, I learned yesterday, almost exactly 100 years ago. June 1st, 1925 was when Pierce versus Society of Sisters was decided by the U.S. Supreme Court. And there the court held that parents have a substantive constitutional right under the Due Process Clause of the 14th Amendment to, quote, direct the upbringing and education of children under their control. And the court ultimately concluded, as a result of that holding, that this law passed by the Oregon legislature could not constitutionally apply to the parents who wanted to send their kids to the Catholic schools and by extension to other private schools in the area. So I think we have a chart here of a number of U.S. Supreme Court decisions in the parental rights area since Pierce, and as you can see from that chart, in the 100 years since Pierce, the Supreme Court has decided a handful of cases in this area that could be said to involve parental rights in the proper education of children. But interestingly, none of those decisions has actually relied upon Pierce's due process analysis for protecting parental rights in public education. And one reason for that is no doubt because the majority of justices today and for some time on the Supreme Court pride themselves on simply applying the Constitution's textual provisions rather than what they perceive as those provisions' underlying rationales. And the problem with the Pierce decision as a legal matter was that there's no express provision in the Due Process Clause of the 14th Amendment that even purports to protect parental rights. And so I think the Supreme Court has been kind of wary about relying on that kind of a rationale in cases since then. Now, the closest the Supreme Court has come to repeating and reapplying its holding in Pierce was in a 1972 case called Wisconsin versus Yoder, Wisconsin had a compulsory attendance school law similar to the one that Oregon had before they outlawed private schools, but Wisconsin had this compulsory attendance law that conflicted with the religious beliefs of the local Amish population. The Wisconsin law required that students attend school of some kind, either public or private, until they were 16, and there were a number of Amish parents in Wisconsin who said, well, as a matter of our religious beliefs, we don't really think it's appropriate for our kids to be wasting their time attending school, public or private, after they've finished the 8th grade. We think that's enough education for them, and in our religious system, it's important that they be doing other things, like helping us work on the farms or working in our carpentry shops or whatever, and they had a religious belief that was what was best for their children. But as often happens, Wisconsin officials thought they knew better than the Amish parents what was best for Amish kids, and so they refused to budge. And that, of course, led to another lawsuit that ended up at the Supreme Court. And the key difference, though, compared to the Pierce case, was that the parents in the Yoder case asserted as the basis for their claim not some ill-defined atextual due process theory, but they asserted the provision of the First Amendment that expressly protects the free exercise of religion. And so in an opinion by Chief Justice Berger, who was my first of 2 bosses on the U.S. Supreme Court, the Supreme Court sustained the parents' First Amendment claim. They held that the Amish belief about education was sincere, that is, the belief that education should be fairly limited. They held that was a sincere belief, and that the Wisconsin law, substantially burdened that belief, and that the state had no truly compelling interest in forcing the Amish, specifically, to continue attending school after the 8th grade, and so the court held that Wisconsin law had to give way to the parents' First Amendment-based parental rights. So that, I think, is the most important legal background for this subject, and today these kinds of parental rights issues tend to arise in 2 main settings. The first is the area of school curriculum and pedagogy, and probably the best, highest profile example of that today is a case that's currently pending before the U.S. Supreme Court and is going to be decided any day now, but it's a case called Mahmoud versus Taylor, which arose out of the school district where my wife Martha and I sent all 7 of our kids to school, and so it's our own school district, and well, what happened there? Well, you all may have read about this case. The school district decided that it needed to help elementary school kids especially, and even preschool kids, learn to be more tolerant of sexual minorities. And so in an effort to do that, they adopted some reading materials as part of the school curriculum, and they didn't include them in the sex education curriculum because by law, parents have an opt-out right in Maryland to anything having to do with sex ed, so they put them in the language arts portion of the curriculum, and initially they said, well, we're going to allow parents to opt out. We realize this may be controversial for some parents, and so we're going to allow parents to opt out. And so when they first started teaching these lessons in the schools, and you know, some of the books were probably things that I as a parent would have found appropriate, but others were things that I would have been nervous about having my 3 or 4-year-old child read in school. Things, for example, about what would you expect to see if you went to a pride parade, and they went into a lot of the kind of unusual things that sometimes happen at the fringes of pride parades, and there are things that you can't really discuss in polite company, but they were in some of these books. So anyway, there was kind of the parents, most of the parents, or many of the parents, voted with their feet when they started implementing this new thing, and many of the parents opted out, and so many opted out that they felt like they had to do something different, and so they eliminated the parental opt-out option, and they announced that we're not going to tell you in advance when we're teaching these lessons. You're just going to have to be surprised. So it was clearly an attempt to try to prevent parents from taking their kids out of school even when they didn't have the right to opt out. And so that practice, that policy was challenged by some folks who were well known to many of us at the Beckett Fund for Religious Liberty. And in fact, one of the graduates of BYU Law School was the lead lawyer on that case. His name is Eric Baxter. And he organized a group. He also lives in Montgomery County, Maryland, just a couple of miles from where Martha and I live. And he organized a group of parents. A number of Muslim families were very concerned about this. There were a number of Coptic Christian refugees from Africa who were very concerned about it. And then there were some more traditional Catholics and other people. And he put together this coalition of parents to challenge this school policy. And they litigated it up the chain. They started in the federal district court in Maryland, and they lost there, not surprising to anybody. They then went to the U.S. Court of Appeals for the Fourth Circuit. They lost there. And by the way, their claim was pretty similar to the First Amendment claim in Yoder. They relied on the fact that based on their religious beliefs, it would be wrong for them to allow their children to be exposed at such a young age to some of the material that was being taught in these storybooks. They said we can't, under our faith commitment as parents, we can't in good faith allow our children to even receive this kind of teaching at such a young age. And so, and that was that basis for their First Amendment free exercise claim. And so that claim was rejected up the chain, and eventually, after losing in the U.S. Court of Appeals, they sought review in the U.S. Supreme Court, and after months and months and months of reconsideration, the Supreme Court finally granted review in the case, and it was argued in the Supreme Court about 2 months ago, I guess, and it was a very interesting argument. There was lots of discussion about the religious concerns of the parents and that sort of thing, and the more conservative justices on the court seemed quite concerned about what the county was doing. And then Justice Kagan, who is not known as a particularly conservative justice, but she does have some deep religious sensibilities, having been raised in an Orthodox Jewish home, and that sort of thing, and just being a tolerant person in general, I would say of her. Anyway, she kind of piped up and said, well, we've heard a lot about religious concerns for this kind of curriculum. It seems to me that even secular parents who have no particular religious beliefs, would be quite concerned about what some of these storybooks are teaching kids who are 3 and 4 years old, right? Which was certainly a helpful sign from one of the justices that the school district, if they want to win the case, they're certainly going to have to get Justice Kagan's vote. So my own assessment, and I think the assessment of most people who watched or listened to the argument, was the parents are very likely going to win that case, and the interesting question is going to be what is the court's rationale? Are they going to go back to Pierce versus Society of Sisters and say, well, there's a general due process right that all parents have to direct the upbringing of their children, or are they going to limit their legal rationale to the kind of narrower First Amendment argument that the court adopted in the Yoder case? So that's obviously one area where there's a lot of controversy over parental rights. Another one that I'll just mention briefly is situations where school personnel sometimes have a different view from parents over how to appropriately deal with health issues in children, including mental health issues. An obvious example is vaccination requirements, which sometimes run up against religious opposition to vaccines and other forms of traditional health care. I'm not aware of a recent court decision on that issue, but virtually all the cases that have been decided on that issue over time have ruled against the parents and have ruled that schools and other entities have the right to require vaccination as a condition of kids participating. More recently, we've seen school officials sometimes second-guess parental judgments about how to deal with things like same-sex attraction or gender incongruity in their children. And we even see occasional examples of teachers or counselors who engage in what is called a social transition of a boy to a girl or a girl to a boy in the school setting, and then take steps to hide that social transition from parents. Again, almost all the cases in this area so far in which parents have asserted a right to prevent that kind of conduct have gone against the parents. And in fact, I'm still smarting from one of those decisions. Just last night, about 10 hours ago, I received a decision from a case like that I've been litigating in California, in which the district judge in California ruled against my client's position and said, no, you don't have a fundamental due process right or any other kind of right to prevent schools from socially transitioning your children. So we'll be taking that loss, which was expected, up to the U.S. Court of Appeals for the Ninth Circuit. But as I said, so far almost all the cases decided in this area have gone against the parental rights claims. I have some optimism that when the issue ultimately gets to the U.S. Supreme Court, as I'm confident it will, that we're going to have a better chance at winning in the U.S. Supreme Court than we have at winning in the lower courts on those kinds of claims. But these are difficult and often controversial issues, and one of the things I look forward to talking about is sort of how do we deal with these controversial issues in a way that I would describe as Christ-like, or in a way that has a peacemaking character rather than a needlessly confrontational character.
Gene, I love that. It's always such a pleasure to listen to you, and I always feel like we have so much more in common, honestly, than differences. But I'm glad you talked about the Mahmoud case. I wanted to focus on that. I just want to stress, boy, I do not have answers here. I just have questions. And I do want to stress what I think is just an enormous amount of common ground, just the respect for family autonomy and that whole Pierce line of cases, where the deep importance of religious freedom and the importance of recognizing, protecting pluralism, the recognition we do live in an incredibly diverse society that includes gay and transgender people of diverse religious faiths and beliefs, and somehow we've got to find a way to live together peacefully and to create our public schools in a way that accommodates that diversity. I think, as the Mahmoud case illustrates, boy, that is not always easy. And I don't know if you noticed, I thought the justices were kind of testier with each other in that argument than they often are. You could just tell this was kind of triggering for a lot of them. But I just can't stress enough, and we did not plan this, but we're in the same spot on this, that this is an area where more dialogue and discussion, like genuine peacemaking, is just so urgently needed. I just so much wish that the situation in Montgomery County had not ripened into a conflict that then led to litigation. And I want to say, if I had been the lawyer advising that school district, I would advise them, do not eliminate that opt-out or restore it once you saw how upset parents were. And that's not necessarily because I think the Constitution requires it, but just out of recognizing that it's such a fraught issue and emotions were running so high, and just a belief that schools should take steps where they can to de-escalate those kind of conflicts, even if it requires them to shoulder extra administrative burdens, which was what they said was their justification. But even before that, even before you get to that, when the school district was searching for books to add to the library and to the curriculum that would show a diversity of families, including families, which makes sense, in which a child or a parent or a family member was gay or transgender, I would have encouraged them, just try to find books that don't politicize any of those identities or anybody's identity, and that don't cross that line between just portraying people in everyday situations, doing kind of everyday things, versus, kind of promoting a political or an ideological point of view about sexuality or gender, or really about anything else. And it's been mentioned several times now. One of the books at issue in the case was this Pride puppy book. I'm like, oh gosh, I mean, on the one hand, it's a perfectly nice little story about a family that loses its puppy and everybody helps them find the puppy. But, it's in this context that many people view as inherently political and kind of triggering. And I'm like, there's just no need to do that. And then some of the instructional materials that were provided to teachers in conjunction with some of the books, which got a good bit of attention in the argument, they definitely crossed the line. And, they weren't just about recognizing that gay or transgender people exist, but they were taking like pretty highly contentious positions on gender and sexuality and what it means to be transgender. And saying things like, doctors just guess somebody's gender at birth and you can choose your gender. Things that I, as a transgender person, do not agree with. And as I was going to make that same point about Justice Kagan, I was like, I think a lot of people probably would have been somewhat upset about these contentions. But, what happens when the school district did not take my imaginary advice? They introduced these provocative books on a relatively, new and sensitive topic, and they did in this really heavy-handed way. And first they allow parents to opt out, then they take the opt-out back. I mean, it's not surprising that it just, gave rise to conflict, and then before you know it, we're in federal court, and then now we're in front of the Supreme Court. And, I do think that's unfortunate because, to me, something that could have and should have been resolved by policy, by local discussion, it's now going to probably result in a broad constitutional rule that may turn out okay, but, almost by definition, it's going to be hard for any rule the court articulates to, in my opinion, to take into account the complexities and nuances of this issue. I was going back and looking at historically cases when parents have challenged aspects of curriculum that conflict with their religious beliefs, and it's really striking. Gina, I think, I'll be curious if you disagree with this, but I think courts generally have rejected those claims, although lots of times they involve cases where the student or the parent does have an opt-out, but short of forcing a student to do something that conflicts with their religious beliefs, such as saluting the flag or something like that, just being exposed to ideas or even having to read a book or engage in a discussion or even repeat certain ideas. Like if you're being tested on evolution, you have to talk about evolution if you want to get a good grade. Courts have generally held that doesn't burden religious liberty, but, this is a new day, and, this is a court that's really shown a willingness to revisit a lot of these fundamental principles, so I think they may do that. I think the challenge here is, how to come up with a rule that permits religious liberty challenges to curriculum, and that's kind of the new line that may be crossed here, but that doesn't just lead to something totally unworkable and invite parents from all kinds of diverse religious backgrounds to bring challenges to, virtually every aspect of the curriculum. And during the oral argument, as you noted, several justices were really pushing the attorney for the plaintiffs, for the parents, and the Solicitor General, who was, also weighed in on the case, to articulate some limit. And they both really repeatedly declined to do that. And I just wanted to flag a couple of examples of that were so interesting. So there's one possible limitation, that there's something unique about issues relating to sex and sexuality. Maybe those are so central to religious belief. Is there some way to fashion a rule that focuses on that? And so Justice Kagan asked the attorney for the parents, she said, I'm interested in the nature of the rule you're asking for. When it started, it was about matters pertaining to sex. But as you'd answered some of these questions, you've basically said, well, my clients have religious principles that conflict with what is being taught. And does it go that far? In other words, does it matter what the subject matter is? Does it matter what the age of the child is? Does it matter what the nature of the instruction is? If so, how does it matter? Or, in the end, is what you're saying, when a religious person confronts anything in a classroom that conflicts with her religious beliefs or her parents, that the parent can then demand an opt-out? And he answered very straightforwardly, it's the latter. It's the latter, Your Honor. So that's very broad. And then there was another possible limitation about parents objecting not simply to books being available or to a discussion, in the books or instruction, but even to just the presence of a gay or transgender teacher in the classroom, and to their child just having to be in the classroom with a teacher who's openly gay or transgender. And so Justice Jackson asked about that. She said, what about the parent the teacher showing pictures from the wedding, or the teacher goes off to get married and comes back and talks about their spouse? Do we have opt-out provisions for children in that situation? And Mr. Baxter, the attorney for the parents, said, again, we think the same rules would apply, so the same constitutional test. And Justice Jackson was concerned about that. She said, so this is not just about books. This is about exposure to people of different sexual orientations, and the objection, the sincerely held objection, that children shouldn't be exposed to this. So all this to say, I mean, I think the court very well, I mean, they're really smart. They may figure out a way to come up with a rule that's more limited. I mean, I expect they will do that. Maybe by limiting what counts as a substantial burden, or in some other fashion. Some of the amicus briefs put forward a lot of possibilities there. But I just want to say, whatever the court holds, we're going to be left with the challenge of how do we protect religious liberty and at the same time acknowledge that gay and transgender people are part of our communities, they're part of our schools. And I just wanted to end on a note of optimism. I think we can do this. We can do this, people, but we do have to, I mean, it really is going to require work, I think, and to come up with some shared principles about how local school districts can appropriately and reasonably recognize the existence of gay and transgender people without infringing on religious liberty. And I don't think it's not going to be pride puppy, but I hope also, on the other hand, it's not going to be, well, you can't have openly gay or transgender teachers. I wanted to say, there's a little foundation to start with, and it's something I think most people didn't notice or even know about, and that is when we challenged the Florida's so-called "Don't Say Gay" law, that actually ended up in a stipulated judgment where we sat down and worked out an agreement with the state about what that law does and doesn't prohibit. Because the fear was, and our allegations in the complaint were, well, we're afraid this is going to mean that a teacher can't have a picture of their same-sex spouse, or mention that a historical figure was gay, or that a student can't talk about their gay or transgender family member, or that a teacher can't be this teacher's sponsor for a gay-straight alliance. And so the state kept saying, no, in court, that doesn't mean that. And we're like, well, would you stipulate to that? And they did. So I think that, could be interesting place to look for possible future discussions. But I just wanted to close by challenging those of us who do care about this issue to take this Mamu case and how painful it was and how much conflict and genuine suffering and harm it has caused and is causing those parents now who, they're having to take their kids out of those public schools as motivation to do more and have some of these conversations and really figure out if we can't work out, Gene, a genuinely peaceful solution.
Thank you, Shannon. Turning to our attendees, our panelists are interested in having this peacemaking discussion and in the theme of our conference today, and we expect that you are too, that you're curious about how to help, and we'd like to know what questions you have for Gene and Shannon to continue this discussion. We have some roving mics available if you'll raise your hand if you have a question. Michael's, thank you.
Is it on? Yep. Thank you both for your presentations. I feel like we live in a time of political polarization on many issues. When we talk about peacemaking, how can we build a culture where we're still trying to be peacemakers if we win, and we're still trying to be peacemakers if we lose?
Thank you, Michael. Your thoughts on that? How do we continue to be peacemakers when we're the winners of a case, and how when we're not?
Well, I would start with something that I know Shannon and I share. We're both Christians. We believe in Jesus' teachings, and I think for those of us who are Christians or people of other faiths that have similar teachings about about peacemaking is we can start there, whatever our religious tradition is, and in Islam, as we know, the Quran frequently talks about the importance of peace, and many of the leading scholars of Islam say Islam is a religion of peace, right? So we can start, I think, with our own religious beliefs, which are likely to be motivating to all of us, and ask ourselves what do those religious beliefs require or suggest we should do. And one thing that I think all of us can do, consistent with Jesus's teaching, is that we can all simply assume that those on the other side are acting in good faith, that they're sincerely articulating and trying to follow the truth as they understand it, and isn't giving people the benefit of doubt as to their own motivations, at least part of what Jesus meant in the Sermon on the Mount when he commanded, "Judge not, that ye be not judged." I mean, what kind of judgment is more offensive than to judge somebody's motives as being bad? You may disagree with their actions, or you may disagree with the position that they're taking, but to judge them as acting out of bad motives is really a harsh judgment. And I think Jesus teaches us to avoid that. And I think it's similar to Paul's teaching in the wonderful chapter, 1 Corinthians chapter 13, on charity, which is charity thinketh no evil. And I think part of what Paul means in that statement is that you don't assume people are acting from evil motives. You assume that they're doing their best to understand and live the truth as they understand it. And of course, in the world today, we see people vilifying each other's motives all the time. In political debates, sort of the first assumption seems to be that if you disagree with me about the war in Iran, or if you disagree with me about this or that, it must be because you hate America, or you're trying to destroy the traditional family, or you're trying to destroy society and create chaos. Those sorts of things. And I think if we can just start by getting away from that and assuming that everybody, including our opponents, are acting in good faith, that's a good place to start.
That's so true, Gene. And I think it was President Reese this morning, my apologies if it was someone else, who talked about, common ground is not something we discover or just come upon. It's something that has to be forged. And oh my God, that is so true. We can find it, but it does require effort. And I think if both sides need to come together and recognizing that, yes, you're going to have to make some sacrifice. Like, that's just part of how finding common ground and compromise works. And there was a recent conference on René Girard in Rome that I've been hearing so much about. I didn't get to go, but I've heard from other people. I've been thinking about that so much, but just how much now we need to break the cycle of scapegoating and violence that he described so powerfully, and that what did Jesus do was a willing sacrifice and a forgiving scapegoat. And we definitely need a spirit of sacrifice and forgiveness. Yeah.
Thank you, Shannon. I think Shira, did you raise your hand?
I did, yeah, thank you. And that's a good point. Yeah, she's just augmented my question. I'm curious about if we're talking about peacemaking, and peacemaking requires hearing different perspectives and engaging with them productively, and maybe not even coming to consensus, but coming to some form of mutual understanding. How can we balance that with, in this case, the issue of the parents are ostensibly saying we don't want our kids to hear this perspective, and this kind of theme in parental rights, and as Mirabella just pointed out, book banning as well. There seems to be a tension that I'm identifying where, on the one hand, we're suggesting we want people to be engaged in this deliberative process, and on the other hand, some of these opt-out opportunities, ostensibly in the name of religious freedom, in my perspective, are making that peacemaking more difficult, because we're not exposing people to the very perspectives that challenge them toward the peacemaking that we're looking for. So I'm curious about that tension and how you guys think about it.
Shannon, would you?
Well, I wonder what would have happened if there had ever been an opportunity for, in a calm, orderly way, to ask some of those parents, are there any type of books that include, gay and transgender people that you would be okay with? I think it's so hard. Part of the difficulty here is that people are starting from such a chasm of just completely different perspectives. And I can, believe me, I can totally see what happened, that there's probably some of the people that picked those books or whatever are like, what's the big deal? Pride parades are great, let's take their kids to pride parades. And to them, it's just so ordinary, nothing troubling or whatever. But then for other people, that is so just foreign to their experience and is jarring. And then there are things in the little Pride Puppy book that, as you point out, there are distressing to people who are just not in that world. And I wish both sides could be more realistic about, do we have to start from just the sort of farthermost edges of what's comfortable for us, and then we're going to stay in the farthermost edges of what's uncomfortable for us and face off across this hostile divide? I really think too, we need better leadership. And I should be careful because I don't know who the lawyers were advising that district, so I should be careful. But I wish they had encouraged more of a spirit of, let's talk about this and compromise. You even saw that in the argument. It was painful, honestly. I'll be honest with you. It was painful, as a member of the LGBT community, to hear some of the justices make assumptions about some of the stuff in those books. Granted that some of the stuff in the books was, a little out there from a lot of people's perspective, but it was still there was a woman in a leather jacket in Pride Puppy. You find the woman in the leather jacket. And in Justice Gorsuch, and I'm not trying to pick on him or anything at all, but he immediately jumped to, well, that was a sex worker. They're asking and I'm like, no, just somebody in a leather jacket, but just the gulf, the complete people just sailing past each other like ships in the night was really painful to behold, both in the incident that led to the case and then a little bit in the Supreme Court argument itself. And it just was such a huge, to me, just, oh my gosh, could we just slow down and find ways to talk to each other and work past some of these common misperceptions?
Thanks, Shannon. Gene, your thoughts?
I love the story Shannon told a minute ago about his efforts to settle the Florida lawsuit, which were successful,
Yeah.
right? And I think some people view litigation as kind of an act of war, but I think, and how many of you are here getting CLE credit for this for this presentation? Here's my comment to the lawyers. Litigation shouldn't necessarily be seen as an act of war. It's very often just a way of getting somebody's attention, right? And getting them in a position where you could sit down with them and work out something reasonable, as Shannon did with respect to the Florida case, right? And Shannon and I have been involved in settling lawsuits over other controversial matters, but I think that's also why it's so important as we work in that field, or as we work in the public policy field, to operate in a way that doesn't make people decide that person's operating in bad faith, and I don't have anything in common with that person, and I could never really talk to them, and I don't dare talk to them for fear that they may, they may slice the legs out from under me if they have an opportunity, right? And you don't get an opportunity to settle a case like the one Shannon talked about by being a jerk as a litigator. You do it by being a reasonable person and watching for opportunities to work something out with the other side. And the fact is, almost all litigation ends up in a settlement, right? In fact, at some point, the Mahmoud case is going to end up in a settlement. However the Supreme Court decides the issue, there are going to be things that are not completely resolved by the Supreme Court that the parties are going to have to work out. And so just if you're practicing law in this area or any other area, it's important to do it in a way to recognize that the person who's your opponent right now is likely going to be your negotiating partner, where the two of you are going to have to work something out and then go persuade your clients to adopt it. And so you want to preserve the ability to have those kinds of relationships.
Thank you, Jean. Looks like we have a question here. Okay, next. And there's someone with a hand up over there.
Hello? Is this on? Hi, I'm Nan Hunter. Thank you for your comments. And I think what I've heard really is what I really feel is that we need to come together as people and start identifying ourselves not by our gender, by our religion, but we need to identify ourselves as people of God, just good people. We need to know that we are important just the way we are. And I'm the founder of a private school, and we have gay children. We have gay teachers. I adore them. They are wonderful. We have a very, it's in California, it's a very, very diverse community. Lots of religions, lots of different things. And because I'm a member of the Church of Jesus Christ of Latter-day Saints, we established that as kind of the rule of law. We don't allow smoking and drinking on our campus. There are things we do. We don't do things on Sunday, period. Just because I believe in that, and I'm the founder, I get to do what I want. But one of the things that I know that is really bad is that when we command people that they have got to do this or do that, they will uprise. Unless, like if you say, you have no more choice in this. People, it makes any of you tell me I can't do something, well, I will show you different right now. And so one of the things that I think as a suggestion, if people don't want their children to learn about transgender and LGBT and all this kind of stuff, what we do at school is we have meetings with the parents and the children, and those who want to come and talk about transgender especially, which is such an issue in California right now, the parents and children come together, those who want to, not those who don't want to. My strong feeling is that the school has no business in teaching this stuff to kids anyway. We're here to teach them how to love one another, how to cooperate, how to work hard, how to be diligent, how to be honest, to forgive one another. I mean, these are the values that we stand on at our school. To get together and we have conferences when there's conflict with our children. We figure out how they can solve their problems from beating each other up. And if they want to learn about this stuff, then bring your mom and dad and we'll teach you about it. But this is not our job to teach you about this in school. I think that's a parent's job. They need to be smart enough and they need to be kind enough to people who want to do this to say, fine, but I'm not going to do it. I think choice and education in the proper place is what we need to do. And I just don't think the schools are the place to start teaching our children this stuff without their parents. I think parents need to be educated along with the children, sex education, transgender, whatever you want. And that's just what I think.
Thanks, Ann. What comes to mind, Jean? Shannon?
Go ahead.
Well, just real quick, I think that, to me, you've articulated a very important distinction, which I think really matters, which is this one thing for public schools to acknowledge the actual reality of the diverse families that exist in the community and just acknowledge that gay and transgender people exist. That's one thing. Trying to take, philosophical or religious or ideological positions about what does it mean to be transgender, that, to me, I wish they wouldn't do that either. I don't think it goes anywhere good. You're almost invariably, you're going to trample on very deeply held beliefs that people had. It's going to lead to conflict. So I'm with you. I think that's a very important distinction.
How can we stop that?
I don't know. I don't know.
Jean, ideas?
Well, the Mahmoud case, if it comes out the way I think it's going to come out, is going to go some distance towards helping that, or at least giving parents with those kinds of concerns more of a basis for a conversation with the local school leaders, right? If the Mahmoud case it results in a ruling on behalf of the parents all around the country are going to, if they're faced with school boards who want to do what the Montgomery County School Board did, they're going to have a good basis for a conversation with the school, because if the school gets sued in a situation like that and they lose, they're going to have to pay the other side's legal fees, right? And that could be hundreds of thousands of dollars or millions of dollars, that are going to come out of taxpayers' money ultimately, and school boards don't like to have to do that. And so a lawsuit is going to be even more of a conversation starter after Mahmoud than it has been so far.
Just really quick, I wish we would deal with gay and transgender issues the same way we tend to deal with other kinds of diversity like race, religion, ethnicity. We just acknowledge the diversity. We don't typically delve deeply into here's, the deep meaning of race, or here, let me tell you about this particular religion and its doctrines. I don't know why we feel this impulse to do that around gay and transgender people, but I don't think it's helpful.
Yeah, and I agree with that, actually. I mean, I think as a parent, LGBT issues weren't as much of a big deal as when our kids were growing up as they are now. But Martha and I deliberately chose to have our kids attend a school where we knew there would be lots of diversity of all kinds, economic and racial and every other kind of diversity, because we wanted them to understand what the world was like. We didn't want them to go off to college or get a job and have that be the very first experience that they met somebody of a different race. That I would have viewed that as malpractice as a parent to put our kids in that situation. So.
Looks like we have somebody ready to answer. Okay, there's a question ready there, and we've got a mic here. Okay.
I am just curious in this discussion about parental rights in these cases, how children's rights are being involved in the discussion as well in these cases. And it looks like in the 1982 case that there was a discussion about First Amendment rights for children. So are we seeing a discussion about that in these sorts of cases, and how are those rights being balanced along in the discussion?
And I think we're talking about the plurality in PICO.
Yeah, that's a great question. It's kind of a technical legal question, but the way the way parental rights works and the way children's constitutional rights work is that in general, children are not considered to be able to assert their own constitutional rights, and so somebody else has to assert them for them. In general, and so that's the reason why in the parental rights cases that we've discussed, you essentially had parents standing in for the children, and the courts just assume that the children would probably agree with the parents' views on whatever religious concerns that they had about what they were being taught or what they were being required to do.
There was some discussion of that, in Yoder about what about those Amish young people? What if they had a different view, and how would that be taken into account? And the court didn't really take it into account in the decision, but it was raised as an issue. I'll just say in this Florida settlement, one of the, I think, very positive things is that the state did stipulate that there's nothing about the law in Florida that prohibits students themselves from saying whatever they want to say in class, or talking about their families, or doing a student report on an LGBT issue or that kind of thing, in recognition that students do have some rights to freedom of expression. So anyway, you're raising an important aspect of this, I think.
Thank you, Shannon. Okay, we have a mic ready here.
Hey, Shannon and Jean, I have a take that I'd like for you to react to that then kind of flows into a question. So here's the take. Shannon, you've sort of said, look, the school district in Montgomery County kind of went beyond merely describing different kinds of families and people. It went into an area of really making moral and philosophical claims well beyond just description. And there was this disdain for many of the parents expressed by some within the school district. Now, my contention is that's not that much of an anomaly. I mean, Montgomery County is not some hippy-dippy, this isn't Berkeley, this isn't like some university town. Like it's just a major kind of white-collar heavy area. And my contention is actually this kind of attitude around these things is actually, I don't want to say the majority way that school districts would be, but it also isn't some, little anomaly in some weird little outlier enclave someplace. I contend that these attitudes are going to lead to more conflict. So I'd like you to react to that. And then the question that sort of follows on to that is, what are the kinds of fact patterns that you're likely to see? Even assuming, for the sake of argument, that this case is decided in favor of the parents, there's still going to be flashpoints around these issues, around parental rights, and about just the disdain that the sort of educational establishment has for those with views that they view as sort of outmoded. What are the other kinds of fact patterns that you think we're going to see parental rights litigation in over the next 5 to 10 years? That's my hybrid question.
Thanks for that great question. Which of you would like to react first?
Well, I just want to make sure I'm clear about one thing, which is that this delving into the moral and philosophical contentions, it was, in my view, just based on the reading the record, at the margins. So I don't want to be clear. I don't think it was totally over the top. It was just there was some of that at the margins that was not necessary and needlessly provocative. And just to be clear about that. And the negative views of the parents who were expressing concerns, I also think, if I'm understanding the record right, that was by some other parents at meetings. I don't think school administrators expressed that. We could double check on that, but that's my recollection of the record. And I don't know, Tim. I mean, where I live, Texas, it's still pretty. There's more people in Texas that would be like the parents in this case than there are that would be, on the other side of it. But I do think you're right. Yes, I mean, I think these very same kind of fights over whether and how there's anything in the curriculum that reflects the existence of gay and transgender people is going to be a big continuing issue for the foreseeable future, along with the issues that you were talking about, Gene, about how do schools deal with transgender and gay kids?
Yeah, my guess is that, if the Mahmood case comes out in favor of the parents, there will probably be a little more litigation over, exactly how far does that go? Whatever principle the court articulates, how far does the principle go, and what does it apply to, and that sort of thing. But my guess is that, once the Supreme Court has spoken there, that the range of reasonable disagreement is going to be vastly reduced. And so, good lawyers are going to be able to figure out, what's the maximum position that I could win and what's the worst I could lose, and they're going to use that information to figure out settlements in those kinds of cases, in most of them. I think in the area of gender incongruity, kids who have gender dysphoria or believe they were born in the wrong body, or however you want to express it. I think that's an area where there's probably going to be a good bit more legal fighting until kind of the Supreme Court decides a couple of questions. First of all, at what point do parents have legal standing to challenge those kinds of policies, which is a huge problem right now, especially when you're dealing with policies that are designed to keep parents in the dark. The general rule, at least in federal court, is that you have to establish a realistic risk of harm. But of course, given some of these policies are designed so that the harm is going to have occurred before, as a parent, you even find out about it. Okay, so there's kind of parents right now are kind of in a catch-22 under the federal law of standing. But then there's also going to be a substantive question that's going to have to be worked out. Is to what extent can parents assert a parental right to avoid, for example, social transitioning of children that falls short of actually providing medications and referring for surgery and that sort of thing. I think in most places schools seem to acknowledge that they would be going too far if they referred a child for surgery without consulting with the parents. But
yeah.
So right now the battle is more over sort of social transitioning, but that's going to, I think we're going to be dealing with that for a while before it gets resolved.
With apologies to whomever's waiting to answer a question, we would like to just have a 1 minute each take-home peacemaking tips on this topic from each of you. Jean, would you please kind of summarize what you'd advise all of us?
Well, I would say to all of us, follow Shannon's example of being willing to work with other people in a way that's not offensive, and looking for opportunity to resolve issues in a way that that each side ends up giving up a little, but they both end up feeling more or less okay about the outcome. And that's what good lawyers do, is they find ways to help their clients resolve disagreements, short of spending millions and millions of dollars in litigation. But I think for everybody else, it's also just what good citizens do, is we try to find we try to find solutions to disagreements that that most people are willing to live with, even if they're not their top choice.
Well, I can't beat that advice. Yes, I think trying to assume the best rather than assuming the worst, and having the courage to keep talking, even if sometimes they can be uncomfortable conversations. I mean, I've just from my own experience, I am so grateful. I'm so grateful I've had the opportunity to be in settings and to talk with people who I initially started out thinking were gonna hold all kinds of opinions or judgments of me that I discovered just was not the case, and it's been such a blessing. So it was something I would wish everyone could experience.
Well, with thanks to all of you for your attention and involvement, please join me in thanking Jean and Shannon.